Cool. Welcome everyone. We're slightly early and we're also on a Wednesday rather than a Thursday, so hopefully you got the memo. Certainly for the people asking questions, I have put a note saying it's tonight rather than tomorrow. But if you're here, it'd be nice to see who's around. So welcome everyone as well. If you're new to the live stream, this is just us trying our best to be helpful with the information we've got. So it's obviously not legal advice. We're going to do our best to give accurate answers. But there's just genuine problems with actually being able to do that all the time. So do treat it with a pinch of salt. And if you could also refrain from asking questions in the first person, so don't ask questions about your own situation overtly. Just make it as if it's about a hypothetical person. So what if someone was in TA and this happened? What would be the answer? You'll get the same answer basically, but it's you'd have to put your personal data on the internet, which is all good. You're right, Lynn. Oh, hang on a minute. I've actually forgot to do a couple of things. Bear with me. I knew I forgot something. So I've just got to do the old back office tick boxing back here. So pop that on and then get that into the chat. Feel like there's some important news I had to share, but I've got literally no idea. I've been training all day, so I'm knackered. Let's pin that. Right, cool. So yeah, I've had 5 questions in come through the week, and three of them are anonymized. So we'll start with those ones. Then we get into the live stream, right, Michael? And then we'll get back to the non-anonymized ones, if that makes sense. So again, it's just my way of trying to incentivize people anonymizing questions as much as possible. Has there been any news this week? I feel like there's something really important. I forgot what it was now. None. I don't know. It'll come back to me if it is. So let's get the old questions up and running. So question 1 for this week. They're all quite lengthy, but not rambling, which is good. So because no one likes a rambling question, but they're just kind of genuinely complicated. So let's go through this number 1. So hold on, I can't see that yet. So section 21, which is valid, was received in December. Council accepted prevention duty shortly afterwards, but took about 4 weeks to copy and paste the personalised housing plan without the person's input. Person has been looking for private accommodation, but to no avail. Housing officer did nothing other than speak to the landlord after tenant already negotiated a further 2 months, only to learn that this agreement had been made, so accepting relief duty. So I think that's saying that the council essentially accepted the relief duty before they actually had to. I think that's what it's saying. So none of which was officially communicated. During relief duty, nothing but a couple of forwarded emails of agencies, 3 in total, with the council is working with. These agencies mostly offer studios, small rooms with a kitchen sink and fridge, as well as en suites for the highest LHA rate for people over 35. Tenant has now negotiated more time with the landlord, but council is trying to discharge by asking the agency to arrange viewings. So the person gets random texts informing them they're viewing a property. Personalised housing plan states self-contained flat, which by definition has a kitchen included, not shared. Person is finally being able to bid, but band C. Excuse me. Despite having been given reason to believe priority needs, mental health issues, if the person declines these way too small and shared facilities, studios, would that have consequences? And if so, which? No decision letter has been sent, so I'm assuming this is ongoing relief duty. Should the council make a final offer? Could one still fight for priority after moving in and get moved up a band on the housing register, or at least get a more suitable accommodation? Feel free to say it's moaning on high level if a 9 square meter room with ensuite with kitchen is deemed unsuitable for a person with a bunch of belongings that needs to be sold. So I'm not going to complain that you're moaning here. That's fine. So let's try and break this down a little bit. I'm guessing the kind of core question here is that whether the council or what this offer of accommodation is legally. So is it a final accommodation offer? Is it a what I call an informal offer of accommodation, or is it something else as well? So I'll try and give this the straightforward answer or bits first, then kind of get into a bit more of the details. So if it's a final accommodation offer, the council would have to have written to you and to say this is a final accommodation offer. If you don't accept it, we will end all duty to you. That or something words to that effect. And if they haven't given you that warning, then technically it's not a final accommodation offer. And so you can, so essentially, let me word this very carefully. You can refuse it. That may well bring the relief duty to an end immediately, but it would also mean the council would then make a final Section 184 decision about whether you're homeless eligible in priority needs, not intentionally homeless, and have local connection, or local connection be sorted out or whatever. So I guess whenever we're talking about refusing properties, we are very, very reluctant to kind of, our default position is going to be to accept the property and then challenge the suitability. However, I'm actually not quite sure how it would work with challenging the suitability of an informal offer. I think you could challenge, well, you could certainly challenge the suitability of a formal offer, a formal final accommodation offer, but I don't think you can with an informal offer. That's my understanding anyway. So I guess the answer here is going to be clarify with the council, what type of offer is this? Is it a final accommodation offer or not? And if it, either way, and ask the council specifically in writing, what are the consequences of me refusing this offer? And then potentially give your reasons as to why you're refusing it. So if the personalised housing plan itself says that you need self-contained accommodation and it's not self-contained, then I'd say that's a pretty good argument there. So it gets more complicated because if I get the Homelessness Code of Guidance up, this is going to fry everyone's brain, so I apologise for that, but it's not my fault. It's whoever wrote the Code of Guidance. So hold on a minute. Because if you start delving around into the guts of chapter 16, I think it's talking about suitability of offers of accommodation. And somewhere along the road, it says that if you're in priority needs, the quality of the accommodation needs to be higher, needs to be better, whatever the right word is. Let me see if I can find it. If I search for priority need here, I might just might take a slight little bit of time to find it here. So right, okay, yeah, so it is 16.20 here. So let me zoom in a bit. So let's close that as well. Whilst housing authorities must ensure any accommodation offered to homeless applicants is suitable, there are additional suitability requirements that apply to private rented accommodation offered under Section 1937F. I've forgotten what that one, we have to come back to work out what that is, to end the main housing duty or secured for applicants in priority need to prevent or relieve their homelessness. So I think that would kick in here. But again, it's just ridiculous already. Private rented sector accommodation must meet the requirements of Article 3 if it is to be considered suitable when offered to bring to an end the Section 193 main duty as a final accommodation offer made in the relief stage, or to an applicant who has priority need in order to prevent or relieve their homelessness. Now, the reason why this is so convoluted is at this stage in a homeless application process, you don't actually know yet whether you're in priority need or not. There won't necessarily be a decision yet. So you might still be in this kind of limbo period. And so actually that makes it very difficult for the council, even let alone the applicant, to know whether the offer of accommodation is actually suitable or not, whether, because it's going to depend on whether you're in priority need. And in the question, I'm pretty sure it said that that's not actually been confirmed yet, although there's evidence that they are in priority need. So I guess the reason I'm saying this is that it just makes it even more like murky and kind of difficult, I think, for the council to really get this stuff right. I'm not sure if that really changes our suggestions here, though. I think basically the answer would still be the same: clarify what the offer is, and also ask to find out what the implications of refusing it are. So that's my attempt at answering this question. Does anyone else want to throw anything else into this one? Getting some shakes from everyone there. So I'm hoping that I think that's basically the straightforward next steps is to get the council to confirm what the offer even is. And I think the way you'd ask that question is, hey council, is this offer of accommodation a final accommodation offer, yes or no? And get them to answer that question. And once they've answered the question, if they answer yes, then you basically need to accept it and you can challenge the suitability of it. If they say no, then you can refuse it, but you then run the risk of being found not in priority need, because as I say, this is the ridiculousness of 16.20 the Code of Guidance. At this point, you don't actually have a firm decision on not whether you're in priority need or not. So it matters. It matters because you don't know, because it affects what the quality of the accommodation has to be and also what the implications are of refusing the offer. So I think, yeah, I guess I'll kind of default to the normal statement, which is don't reject any offer of accommodation unless you literally can't move into it. You right, Cheeseface? You right, DC? You're at Detox. So yeah, as I say, unless anyone's got anything to add to that, I'm hoping that that kind of gives some information, which is vaguely helpful. And as I say, part of the complication is that the law itself around this is really stupid, but it is what it is. So yeah. So question two. By the way, to the person who asked this question, feel free to come back and get more clarification because there probably is more questions that's then raised. So yeah, question two, looking for advice. Vulnerable adult left street homeless by the system. I'm supporting someone with physical, mental, and learning disabilities who has been accepted as homeless but wrongly denied priority needs. She is currently sleeping in a car. Despite this, there's been no valid decision letter, no personalised housing plan, and every conversation has been a mess of delays, opinion-based reasoning, and even some shocking comments from a senior officer. I'm preparing to hit this from every angle. Section 202 review, formal complaint, emergency legal letter regarding rough sleeping, subject access request to expose their internal handling, MP escalation, ombudsman referral. Is this the best approach or am I going overboard? Is there a faster way to secure emergency accommodation? Has anyone here done a full multi-track challenge like this? Any insight, tips, or watch outs? I want to make sure every angle is covered. Now, the good news with this question is that it seems that this person, because this was asked this morning, and it seems this person has now managed to get the homeless person into hotel accommodation for a week or so. So luckily, it's a slightly less urgent than it was. But all of these suggestions are very kind of are very coherent, I guess. But if we just kind of challenge or kind of clarify a few things here, and I did go back to the person to kind of get a bit more clarification, because in effect, it seems like, judging from what's been said, that the council has kind of provided something in writing, sounds almost like a napkin or something with the word Section 184 on it, but it in every other way it doesn't resemble a Section 184 notification. So in one sense, that means that you can't ask for a Section 202 review until there has been a decision to challenge. And one of the things a Section 184 decision has to include is details of how to challenge it. And I'm pretty sure whatever they have actually got in this situation, it doesn't include those instructions. So it's not a valid Section 184. So you can't do a Section 202 yet. But you definitely can do a formal complaint. You definitely can escalate to the MP, and I'd say escalate to your councillors exact at the same time, probably in part of the same email. You can go to the ombudsman. You can, as in you can write to the ombudsman and explain the situation, but they will most likely come back and say you need to exhaust the council's complaints policy first. However, we did have that case we discussed about 6 months ago where there was a domestic abuse survivor who was basically still homeless, and the ombudsman actually investigated prior to any complaint being dealt with because of the urgency of it. So I actually don't know what their kind of policy is on this is, but it does seem they do have discretion sometimes to investigate things which haven't gone through the complaints process yet. And there's loads of different things to complain about. Now, excuse me, given that this person is now in accommodation, I'd say the thing you want to focus on most of all right now is to show that they're in priority need, because the council in effect has accepted there is reason to believe that they might be in priority needs, but that's not the same thing as actually being in priority need, because priority need is going to be the thing which you want to shore up to make sure that there is going to be some kind of long-term duty to house them, or yeah, longer-term duty. So that's probably what I would do in this situation. I'd be basically seeking out medical letters, any sort of supporting letters, social service involvement or whatever, basically looking at that test of vulnerability so that you've then got that kind of set. And then the rest of it, you can probably, you can, a lot of it's going to probably be about waiting until later to complain, because they're all good complaints. In fact, there's no PHP, the fact there's nothing, no kind of whatever, no proper assessment of priority need and so on. So there will be good cause for complaint, but I would say focus on getting the duty accepted first and then worry about that stuff. Now, the other thing that they don't mention here that I guess again is easy for me to say is that you also want to involve a solicitor, if you can. And actually, this was an illegal aid desert, but that doesn't stop you going to solicitor firms in London. I'm pretty sure Virgo that Will and Karis work for are at capacity at the moment, but obviously that can change over time. So yeah, unfortunately, there isn't a lot of capacity out there a lot of the time. But those are things which I would kind of answer the question to. So again, I just open it up for the others to give their opinions about this. Did I miss anything, or did I kind of get anything wrong there? No, get some shakes of the head again. Cool.
I, I,
think
I can come back on that. Sorry, Shannon, you go ahead.
I was just going to say, and apologies because I might have missed you saying it, but did you say about a Care Act assessment?
I didn't say that. No, good point. Yeah,
It,
really good
yeah,
point.
I mean, it might not be relevant, but I'm just thinking if it's someone with sort of that many needs and depending on the severity of like learning disabilities and care and support needs, it might be worth also requesting a character assessment. And that will only strengthen sort of any arguments for priority need and stuff. And again, along a similar sort of note, but potentially a safeguarding alert, if there's sort of any signs of self-neglect and stuff. Sorry, Will.
No, nothing, no. Uh, No problem. I was just going to say that I guess the multi-track approach is is good to do, and you shouldn't really not do anything because my sort of way of thinking is it's best to be nasty about with the council while you can still be nice about it, if you see what I mean. And just get in there as soon as you can. Some of the stuff's going to be overlapping because you can't really make well, I mean, like Mike says, you can't really go to the ombudsman until you've made the internal complaint. Um, but I mean, maybe we should try and think of a way around this. But the judicial review preaction letter, which is what a solicitor does when they get involved in something like this, is a really useful tool, and it's not necessarily something that members of the public couldn't take up. And in theory, judicial review itself, I mean, maybe we should be looking to a future where people can actually bring their own judicial reviews, and maybe that would result in the courts being less running it all as if it's some sort of thing that's limited to people who've had a sort of graduate education and law training, because you can get exemption from the fees if you're on benefits. Um, the problem, of course, is that it's all legal gobbledygook and you can fall down because you haven't sort of used the right formula. But the nice thing about writing to the council, sorry, one of the things with judicial review, for people who aren't familiar, is before you can go to court, you have to show that you've complied with the pre-action protocol. And what that means is you have to send a letter to the council, and the letter consists of saying this is what's happened. Like Mr. Bloggs, this person applied to the council as homeless. They've been left sleeping in their car, even though they've given evidence to show reason that they're in priority need. And then you set out a section saying what the law is, which is basically just copying and pasting some sections from the Housing Act 96. And then you say what the issues are, which is basically the council should have done this. And then you say, then you say what I want the council to do. And in this case, it would be we want a proper personal, we want a housing needs assessment report, we want a personal housing plan, and we want suitable accommodation and some indication as to whether a duty's been accepted. And then you give a deadline for when you want that, which is normally 2 weeks. So it's quite a good way to, I mean, if people were to start doing those, if only as a sort of formal complaint process, then you've got everything in there. The difficult bit is filling in what the law is, obviously, because it's easy to me, but I've been doing this for years. So I would say, yeah, get if you can get a solicitor to do that for you, that'd be great. Because at the end of the day, the problem with making loads of complaints is they can take quite a long time to be dealt with. And you can, as Mike's video on making a complaint says, your first response to a complaint is likely to be less than helpful. So yeah, that's my sort of speech. If you can get a solicitor, it really does help with this process. And then you can go to court after 2 weeks and get an order making them do things. And it really does make a difference. Like, I've just sent 2 pre-action letters in the last couple of days. And I got letters back saying, okay, we'll give them temporary accommodation tomorrow. And it's that fast.
Yeah. I mean, so Will, you've got that video on your channel, which is how to write a pre-action letter, right? So, I mean, in one sense,
Did I do that? So I've forgotten about
at
that.
some point there is, yeah. I mean, or if it might need updating or whatever, but I just
Yeah.
wonder if actually you're right that actually it probably is plausible, certainly to kind of have make a good draft of a pre-action letter or kind of the beginnings of the case, and actually that's also going to, I would think that would make it more attractive when you're ringing around solicitors to say, look, we've already got a pre-action letter drafted here. there's actually less for the solicitor to do. But I think just the question about going overboard here, personally, I would say it is not going overboard to expect the council to follow the law, and therefore do everything you possibly can to make the council follow the law. So I think these are all really good things, basically. But Shannon says adds in the kind of getting a Section 9 assessment under the Care Act, and also as Will's kind of saying about going into more detail about getting a judicial review proceeding started if you can get a solicitor. So yeah, right, number 3. This is so guys, by the way, in the live stream, this is the last question coming up that is anonymized. So we'll be going to the live stream shortly. So if you want to put a question in, now's a good time to. So someone I know has been staying in temporary accommodation with the council for some months and advised it'll be years before offered a council or a housing association property, which is within their affordability. They've been advised that they can approach another council as homeless. They have an appointment next week to begin the homeless application process with the second council and withdraw from the original council that is currently providing accommodation. My question is, if the new council refer back to the original one, can the original council push back the referral as per the homeless person's request to the new local authority they choose to live with? This is what the original council has advised the person who just wants to check this is correct before withdrawing. The original council has made a decision that they owe the main housing duty under Section 184, just yet to receive any offer of permanent accommodation, and told it could take years. Just to add, the new council have already declined an application to join the register twice due to the lack of local connection, despite my sister living in the area for over 8 years. So sorry, it's not anonymous, but anyway. They have said this isn't in accordance with their own policy. My friend was advised by an advisor at the new council that the approaching them as homeless could help bypass this. So I think this is essentially phenomenally bad advice from the council. This is like nuts. I have gone back to this person and said, don't do that, because it's one thing to withdraw an application when the council hasn't yet reached a decision. So you approach one council, they place you in interim accommodation under Section 188. Yes, you can withdraw that application and apply somewhere else, and you're okay. But in this situation where it seems the council has accepted the main housing duty to the applicant, so effectively they have a guarantee of settled accommodation, although they might be kept in temporary accommodation for many years, to basically abandon that and approach a different council. Ordinarily you'd be intentionally homeless, because arguably you wouldn't be in this case because you acted in good faith because you followed the advice of the first council, but that's not a good game to play, to be honest. So yeah, so I would say don't do it, or if you are going to do it, get it in writing from the council that everything's fine, and then probably still don't do it, because as I say, there is that kind of good faith argument against being found intentionally homeless when, if you've been told by council that it's fine to do it, in writing, and it's very clear, and then you go and do it, and then that turns out to be used against you, then there is an argument, as I say, that the kind of you shouldn't be found intentionally homeless. But then you still run this problem of, I guess in this case, what's happening here in terms of local connection is that it most likely is they're applying the parts. So that says they've declined an application to join the housing register twice. That's probably because this person doesn't meet the Part 6 definition of local connection, but they would meet the Part 7 definition of local connection if they were homeless, which I think is what the advisor's saying. I just think the advisor's getting badly confused about the way all this works. So that's as I say, that's how I'm reading that question, and that's my response to it. But again, yeah, got other guys, do you want to just kind of add in or disagree with anything of just what I've said there? Because yeah, as I say, my understanding is once section, I mean, it says Section 184 there, but I think they mean Section 193 because they're talking about the main duty. So I think I should say Section 193. But if that's been accepted, then effectively you can't just go and approach a different council. So yeah, do you guys want to say anything different from what I've just said there? No, cool. Well, go on, Shannon.
Well, so I completely agree, but I think I'm just being slow tonight. You just said you couldn't approach another council because the main duty's been accepted, but can't you have more than one homeless application as long as both local authorities are aware? Couldn't you have more than one application open? So is there an option that they could not close this one like you've sort of suggested because so many red flags, but also approach another council as long as they've let them both know?
So, well, you could make the approach, but the second council was going to say that they're not homeless. They'd say you've got accommodation which is available for your occupation, And it's it's going to be it's a long-term thing. I appreciate you might move because it's temporary accommodation, but
Okay.
yeah, once night, yeah. So I would, that's my understanding. I say I've not seen it myself, but Section 193 effectively, I don't think you would be classed as being legally homeless anymore.
Yeah, yeah, I'm with you.
Because although the social housing has not come through, and I guess it's not unusual at all, particularly in London and kind of the big cities, for it to take years that people will be stuck in TA. I mean, I'm happy to, as I say, I've not seen it myself, so I'm happy if I'm wrong about that. But yeah, I think the short answer is make sure that the council's properly advised you in writing, and as Shannon says, actually the safer bet anyway would be to approach the other council whilst you still got the open application with the first one. I'm just not even sure if the application would be classed as open once the main duty's been accepted. I don't even know how that would work. So yeah, anyway, so yeah, hopefully that answers the question. It's probably a good example of why it's so important when you're getting advice from anyone to get it in writing. So if your housing officer saying something, just make sure they put it in an email, and it's very kind of clear what it is they're saying. There's no room for confusion. So question I don't know the answer to, but I know that Will and Karis will. So question 4 for the night is, can a person be awarded financial compensation from the council or court if, for example, at judicial review, not to accommodate pending the review court makes a decision in the person's favour? So I guess that's what they're talking about, is that when you get down the review process, the council no longer has a duty to house you. They only have a power to, which basically means if you meet certain criteria, then they should house you, but it's more difficult to fight. So it's easier to kind of trigger a duty than a power, I guess, is probably a clumsy way of saying it. But yeah, Will or Karis, what's the answer? Because I don't know. It seems like there should be, but I have a feeling the answer is no. But yeah.
Yeah, I think that's a good way of summarizing it. The general position is that the sorts of things we're talking about on this live stream is what's called public law duties. And public law duties generally don't give rise to private compensation rights because the duty is owed to society in general and not to you in particular. That's the simplest way of putting it. Whereas if I make a contract with you to sell you something and it turns out, I sell you a car and the wheels fall off, you can obviously say, well, you're in breach of your contract. But there isn't really a contract between me and the housing authority to give me a house. It's just the law says that should happen. And that's the technical argument. The policy argument is that obviously local government, if they had to pay compensation for every time they screw up, they would go bust 10 times faster than it looks like they are anyway. I mean, they would just be sued. I mean, I was doing a preaction letter today to a council, and I went through the history of this guy's application, and he's just been messed around about 5 or 6 times, just ridiculously bad decisions. They found him they said he wasn't eligible on immigration grounds, then they withdrew that. Then they said he wasn't homeless, and then they withdrew that. So they then made a decision that he wasn't eligible again. And it just goes round in circles. The only exception to the rule about damages is if the treatment you get is so bad that it amounts to like cruel and unusual punishment or that sort of thing, and you're into the realm of Article 3 of the Human Rights Act, which is I mean, it sounds melodramatic, but your right not to be tortured or treated in a cruel way. If you're over that threshold, which isn't that difficult to get to, given what people can suffer, then you could be looking at a claim for compensation as part of judicial review proceedings. And it did seem to be moving in that direction a couple of years ago, but I haven't heard of any cases lately. And the general rule is that you won't. Sorry if I go on too long, but there was a case about 10 or 15 years ago where a lower court did award damages where the local authority had failed to rehouse some people, and they were really badly abused by people in the area where they weren't rehoused from. And obviously the judge in the lower court was so appalled that they did make an order for damages, but it was overturned on appeal on that basic point that it was a public law duty and not a private one. So unfortunately, you're not going to get compensation you're unlikely to get compensation through the courts, but you can of course make a complaint and go to the ombudsman and get something, possibly, but that's as good as it gets, I think.
I would just say it's a very Americanized and movie way of looking at things, that you're going to get compensation through the courts.
Yeah, cool. That sounds good because I'm actually just going back to that previous question to see if I can find anything about it on by Googling it. And if I just share this screen over here, so the question of, are you still legally homeless if you're owed Section 193, or probably a better, more precise way of saying it is, can you apply to a different council if you're owed Section 193? This doesn't exactly answer, but so this is subsection 9 of Section 193 of the Housing Act. So this is just this is what it all looks like. And if we go down to subsection 9, it says that a person who ceases to be owed the duty under this section may make a fresh application to the authority for accommodation or assistance in obtaining it. And although it doesn't say about approaching a different authority, I think that's probably backing up what I'm saying in terms of, whilst you're owed the duty, you're not, you're not homeless in this sense, and so you can't approach another local authority, or you can't make another application. You could approach another authority, but it wouldn't kind of kick in until like you are now homeless again. And I think that, as I say, that would be a case of being treated as intentionally homeless because you had what should have been a suitable offer of accommodation, like long-term accommodation, through the main duty, even though it wasn't actually given to you yet, but you basically turned that down in favor of being homeless again. That would be the way I've seen it. I'm going to keep looking at this question because it's an interesting one. So yeah. Right. So there's some more questions coming in the live stream, I think. Right. So next question. Hey, right, Tiff. Is this one here? So question 5 for the night is, oh, it's not there at the moment. Hold on. What's going on? If the person is in 6 months in private rented digs, council has given support on go ahead, but the landlord refuses reference, what's the next move? Okay, I might need a bit more information about this question, because I guess the council's given support on go ahead. So yeah, I don't. So I might need just more information to clarify the question, because a landlord reference won't usually be an issue when it comes to councils in general. I don't know how that might kick in actually. So yeah, if that person could maybe just elaborate on the question, that'd be awesome. Meanwhile, we're just going to go to the other questions that are coming through the week that are not anonymized. So question 6 for the night will be, have this question, can you please answer if you know? My adult daughter and I have made an application to the council, section 21. We both have serious conditions. Meanwhile, my daughter's PIP stopped, which I think is very unfair because her condition has not changed. Now we both receive only ESA, low income only, and I receive housing benefit too. How stopping a PIP can affect our application to the council, please? So in one sense, they're not, I mean, in itself, there's no reason why that would affect the application to the council directly. Obviously, if the PIP had stopped because that person's health had improved, then that would potentially mean that there's less reason to see priority need or whatever. But if both have serious conditions, I don't think that would be relevant anyway. And just to say as well, I mean, that's probably a rather clumsy way to say it, just to make the point that whether or not you receive PIP, there's a correlation between receiving PIP and being in priority need, but there's some big they no way equal, and one doesn't equal the other. So there'll be plenty of people who are in priority need who don't get PIP, and I guess technically there might be some people on PIP out there who aren't in priority need if they were to become homeless. So I think the answer there is it doesn't directly affect anything, I'd say. Although certainly you'd want to appeal that decision that it's stopped and get it reinstated if you can. But I guess it might have an impact just on your kind of, I don't know. As I say, I'm not quite sure what situation it would make a direct change to your housing. It would obviously make a difference to your life in terms of what support you're getting and what you can pay for and so on. But in terms of housing costs, I don't think it's going to change much. So yeah, I don't know. That was a bit of a rambling answer to that one, but I don't think it's going to be too significant, really. I don't know if anyone else got anything to add to that.
No, I haven't.
No. So yeah, so I think yeah, basically appeal the PIP decision, but and tell you do have to tell the council. I guess it's probably worth saying that because you need to keep the council up to date with your circumstances. But I don't think this is a circumstance or a change in circumstances which really going to make much difference to an application, because as I say, whether or not you're in priority need is going to be independent of the PIP receipt. Basically, it's going to be based on what conditions you have and what are likely to happen to those conditions should you become homeless. That's really the test. So receipt of PIP can throw up useful information sometimes, but it's not, you know, as I say, it's not like a passporting benefit or something. So yeah, so I'm just going to, so this is, I think this is a follow on from question 5, potentially. What, oh, I hate Times Roman. Hold on, guys, I can't stand that. Let's get Aptos back. Grown on me. Right, there we go. So yeah, if person, so yes, in private accommodation for 6 months, council's given support and go ahead, the landlord's refused reference, what's next? But if we got to add that the council only has 56 days duty of care, this person has sent various emails and landlord flat out refuses reference, which is stopping that person from a 12-month property opportunity. So I assume what that means is the council's basically saying, yeah, we can help you, but you need to get a reference from your landlord. I think that's what they're saying. What can you do about a landlord refusing to give a reference? That's difficult. I'm not sure there's anything you can do from from a landlord refusing to do that. I guess trying to have a reasonable conversation with them and explain why it matters. I mean, you know, I don't quite know why a council would why a landlord would flat out refuse to give a reference, other than they don't potentially want the person moving out of their property, maybe, or there are some serious kind of issues, whatever. But that's not indicated here. So in terms of, like, you know, not a good tenant, but I guess yeah, it's not. That's not what I think is happening here. So yeah, I don't know is the answer to that, probably.
Isn't this a situation where, like, actually the housing officer should be your best friend? Because arguably, like, the housing officer should be the person, like, having this relationship with the landlord and explaining the importance and getting that reference on your behalf. So I don't know. I think if it was me in this situation, I'd probably reach out to the housing officer and say, look, thank you so much for all your help so far. Really, you know, excited about this 12-month property. I've hit a barrier. Is there anything you can do? Because obviously I don't want to make it worse. And they should sort of bite your arm off, really.
Yeah, I mean,
You'd think.
yeah, and again with the landlord. So if so, say the tenant was a bad tenant, and the tenant was saying, yeah, look, I can get somewhere else, then again, the landlord would be motivated to give a reference of some kind rather than refuse it. So it's a bit of I think that's a fairly unusual situation to be in, to be honest, which doesn't really help the person asking the question. But yeah, I think Shannon's right. Probably try and get the housing officer to potentially contact the landlord and just try and get something that way, and just, I don't know, plead your case, really. But I don't think there's any way that you can force the landlord to do anything. So I think if you can't convince them nicely, then I think there's a limit to what you can do, really.
But can I just say,
Yeah.
am I missing something or being thick here? Because I can't understand why the council have given a go ahead in this situation to help, but are still requiring a landlord reference. Because I mean, are we saying the person's been evicted from their previous accommodation? Or are they
So
saying they're still in the place with the landlord is still their landlord?
um, so I don't know. That's probably good to get clarification from
Because
the
if they are
person.
still the landlord, then presumably, unless a valid Section 21 notice has been served, etc., then they're not homeless, and if unless the accommodation's unsuitable for them. But either way, a reference isn't really needed. I mean, I've never, in all of the work I do in local authorities, a landlord reference has never come up because either you're homeless, sorry, either you're intentionally homeless and you don't need a reference. The landlord just has to say, yeah, I kicked them out because they were rubbish tenant or they were doing things wrong. But you wouldn't say, well, it's only dependent on the landlord giving you a good reference. Because as long as the landlord doesn't say it was deliberate act or omission and it was reasonable for you to stay, you're unintentionally homeless.
I would speculate here that we're talking about a council doing stuff within the relief duty, which isn't a duty. It's not part of their main. Yes, it's not kind of a final
Mm.
accommodation offer. It's more them trying to relieve someone's homelessness by, kind of trying to be vaguely helpful. I think that sounds more like what it is. Because I agree. Yeah, I mean, the question would be here is, what is the situation with
Yeah,
the?
I'm surprised they accepted a relief duty if they're not actually homeless, but
Yeah. yeah, again, if the questioner could maybe clarify that as well, that would be helpful as well. So we can always come back to this question. Cheeseface just mentioned, so just pointing out that being on PIP, being in receipt of PIP, is going to mean that you're not subject to the benefit cap, which can be very helpful in general. Obviously, it means a whole range of properties are going to be affordable for you that otherwise wouldn't be. I don't know how likely it is where you've got two people in a household, how likely it is you're going to be subject to the benefit cap. I guess it is possible if you're in, kind of London or something where rents are so high. I don't know. But I mean, generally, I think the benefit cap starts kicking in when you've got, kind of, I don't know, is it like 2 or more kids? I can't remember what the sort of calculations are. So, hey, what's there back? Oh, Struth, we've had a spate of questions just come in. Hold on. So, is that a question? Vulnerable person's been unlawfully bullied and harassed by landlord, unable to get an advocate lawyer. Now DWP have stopped all this. He instructed landlord to stop HB. Okay, I don't know how that fits into what we're saying there. So forgive me for that one. Might need some clarification. Lynn's just making a really good point here, actually. Oh, it's not a question, but I'll put it into the thing. So, help to bring judicial review from a well-trained Mackenzie friend with training in-house would be very helpful. I don't think they exist yet, but it would be possible to train volunteers. So, I think this kind of goes back to what you're saying, Will, about. I mean, I don't know, Will, because the Mackenzie friend is like something very specific, but I think I get the idea of a Mackenzie friend is like an untrained advocate or something. When I say untrained, I think they still get training of some kind, like some minimal training. But whether that's something for us to explore between our channels or whatever, just to sort of maybe put some stuff in place to help people get a bit closer to being able to kind of get judicial review stuff happening without having to get a solicitor. So how are we doing for time? We're doing all right for time. So question 8. If someone has been told by someone from the housing switchboard via a phone call that this housing officer has proved his case for him to be placed on the housing register whilst he is in interim, there's a bit more to this. How long does it usually take to receive the final decision letter once the housing officer has approved it, as he was told that this has been sent to a manager for approval? Okay, so someone's in interim accommodation, so there's reason to believe that they might be homeless, might be eligible, might be in priority need. That also means that the relief duty, sounds like the relief duty will currently be in play. And because you're on the relief duty, you have to also be placed on the housing register, although in most councils you'll get a lower banding in the relief duty than you will in the main housing duty. So how long does it usually take to receive a final decision? I think we'll revert here back to the 56-day period. So let me get it up because we haven't actually shared this for a little while. It's a pretty common question because it affects a lot of people. But if we go to, I never remember what paragraph it is, but if we search for day 57, it comes up. So 14.17. So where the housing authority is satisfied the applicant has a priority need and has become homeless unintentionally, the relief duty comes to an end after 56 days. So I think that's what is likely going to happen here. Can't guarantee it. Housing authority should not delay completing their inquiries as to what further duties will be owed after relief duty. Where the housing authority has the information it requires to make a decision as to whether the applicant is in priority need and became homeless unintentionally, it should be possible to notify the applicant on or around day 57. So that's day 57 from whenever the relief duty started. We had this conversation last week where we're like, at what point does the relief duty start? How soon after making the application does it start? And my answer is still going to be a couple of days, really. We're talking days, not weeks. In cases where significant further investigation is required, it is recommended that housing authorities aim to complete their inquiries and notify the applicant of their decision within a maximum 15 working days after the 56 days have passed. So going back to the question, hold on, where is the question? It would be a case of tracking back when did that relief duty start, and that should be on the letters you've received from the council. They should be pretty clear where it is, and then going forward to whatever day 57 is on your calendar, and that is when you should get the final decision. But lots of councils basically don't comply with that timescale, so you might initially want to start just politely chasing it, and then start more robustly chasing it if you don't get an answer. But I think that's the answer to the question. And if you're owed the main duty at that stage in the final decision, then you will probably go up another band, is my guess. I don't know which council this relates to, but most councils, that's how it works. So yeah, so oh, Struth, it's going right. I might have to just kind of call time on new questions in a moment. That's gone black and white for some reason again. Hold on. So do you have an email of either of you to provide assistance regarding legal matter compensation towards council due to failure of full investigation into our original council application? So Carrison will are kind of constrained by legal aid as to what they can and can't do, and they're also at capacity, and I'm also at capacity, and Shannon's also at capacity. So we can answer kind of discrete questions about what you can do, but I don't think any of us have capacity to help with kind of getting compensation from the LGSCO. So unfortunately, I don't think there's much we can do directly. But as I say, we'll try our best to kind of give answers in a setting like this where we can maybe kind of give you a steer. Plus, there's some pretty robust, pretty detailed videos on the channel about making a complaint and that sort of thing, which would also probably give you some good pointers. So yeah, unfortunately, we can't help there is the answer. I will just hold on. We will just call time on this as well. So any further questions after I put that message in, we have to roll on to next week or so. So Tiff, I'm confused by which one you're referring to, which question you're referring to. Can you see which number it is? That might help.
I don't
Cool.
think it's that. Is a previous comment saying disability part of ESA was taken off, amount given, no explanation. You see
Right.
that one? And then
Yeah.
there's one afterwards. I think
So
we've
question
covered this one
6.
before.
Sorry, have I missed bit in the chat?
I think potentially.
Oh, hold on. Bear with me. So okay. Okay, yeah, that's right. Yeah, I've missed it completely. Hold on then. Hold on. Although I don't know that we're going to be able to answer because it's more of a benefit question, but let's see what we can do. So,
I think there's 3 parts.
yeah, cool. Yeah, I don't know how I missed that. Sorry. So disability part of ESA was taken off amount given, no explanation. ESA then dormant due to not able to apply for universal credit. If housing benefit offers no tenant under DWP, CTR, what's CTR again?
Complex team referral.
Thanks. Shouldn't housing benefits still be paid? Are DWP allowed to legally tell councils to suspend vulnerable people's rent? Isn't that madness when DWP put the vulnerable person in the CTR category? The vulnerable person has been unlawfully bullied and harassed by landlord, unable to get advocate and lawyer. Now DWP have stopped what ESA, instructed landlord stop ESA, stop housing benefit. Yeah, I don't know is the answer. It sounds dodgy, but so I don't understand why that would be possible. But as I say, I really don't know much at all about benefits. So unless any of the other 3 know the answer to the question, I'm not sure we can. Yeah, I'm getting shakes the head, unfortunately. There are a couple of Facebook groups which kind of focus on giving advice for benefit issues. I've forgotten the name of the one I'm a member of, but they seem to know what they're talking about. So, and I think, I guess, generically, we can probably say write to DWP and write to the Housing Benefit Department and just ask what's going on, ask for clarity of what's going on, write to the landlord to say, you know, something's happening here. We don't understand it yet. Can you just, bear with me? I mean, if it's a social landlord, then you'll often have like income and sort of benefits advice teams within those housing associations, which in my experience, they can be really helpful. So again, it might be a case of reaching out to them if we're talking about social housing here, but I don't know the answer to the question at all, I'm afraid. Cool. Done that. Good to hear it, DC. Yeah, I think hopefully you'll be able to find somewhere which is a good organisation to kind of kind of work with. Okay, so I'm just going to delete a couple of ones which are in the first person. Just, I know it seems like a bit of a weird thing, but as I said at the start, questions need to be posed as what if questions rather than about their own situation. Yes, and there's a follow on just for that question there, but I don't think it kind of changes the answer, which is that, yeah, we don't know for sure, but certainly there might be some organisations out there who would be able to help out. And I think just kind of putting it in writing is just going to basically mean that it shows that you are trying to sort the situation out and find out what on earth has happened in the situation. Cool. So, I think that's it, guys. Let me just check. I haven't done the one from last week. As I say, we're going to stop questions there coming off that point. So if you've got further questions, roll them on to next week. Just check I haven't. I know there is one further one that came in through the week, which is as follows. So question 11, I have section 21 ends in 5 days. I have 4 disabled children with different needs. I myself have heart disease and possible MS. By the way, this is why I don't like people putting their own data on the internet. I mean, I appreciate I'm hiding it here because you guys can't see where it came from, but this is not sensible to put this level of data on the internet about yourself. So and it's not necessary to get an answer. So I have MP and councillor involved in 3-bed at present, but health and housing stated 4-bed because of children, etc. They say they don't have them, and I'm at bottom of band still, and now being told that they won't do anything now until the possession order comes. I have all emails etc, and my officer is now going to wait till the 12th of May. Put in complaint in, and chief exec is meant to be ringing on the 28th to discuss my issues. Try to go private again, but it's double to what we now pay. And everywhere wants a guarantor due to past IVA, which I found out what it means this week, but I've forgotten again. It's like individual voluntary something or other. Help me out, guys, if you know what it is. As I said, I did see it. Individual voluntary arrangement. So I think it's when you kind of like put all your debts together. That's my understanding. So yeah, this is going to be a really depressing answer. So some councils literally have it. Well, it certainly seems that a lot of councils have little, if no, 4-bed properties available. And so if you're in the bottom band and you need a 4-bed, again, based on the average council, you're not going to get housed anytime soon. And so I don't know what you can do to speed that process up. I guess I would do it depressingly. I'd say your best option might be to get suitable, decent quality temporary accommodation and know that you're going to be there for a long time. I don't know how to give a more positive answer to that, unfortunately, because yeah, as this person rightly points out, 4 beds in the private rented sector are going to be unaffordable. Like almost certainly they will be. I guess we might be talking about here where we've got quite a few benefits coming into the household, but that's it's going to be. It seems quite difficult to be able to find something which is affordable.
Is
Shannon?
this not one of the situations where it sounds like they haven't actually accepted sort of the homeless application yet? Because that would explain the low banding on the housing register, and being told like wait until possession order and stuff, which obviously I think we show most weeks, but in the code of guidance, that's not legal. So it might be a case of maybe using that bit of code of guidance. And I think there's a video on the channel, isn't there, around like wait till the bailiffs come, or it's called something like that, isn't it, Mike?
Yeah.
So that might help out.
I would suspect that they're under either prevention or relief duty, and they're getting that low banding because they are owed at least a prevention or relief duty. So I mean, yeah, so I think you're right. I think if it's going to speed things up to make sure that's been done properly. But I have a feeling that actually the housing register route out of being homeless is not going to be the option that's going to be the one that comes through. I think the council's going to have to be quite creative about how you actually house a family with 4 disabled children in suitable accommodation. I think there was a case in Norwich. It might not be Norwich, but where the council had a duty to provide very specialist accommodation because they had a family with lots of needs and stuff, and effectively the judge ordered that the council build the family something because they basically said we haven't got anything. I couldn't tell you what the name of that case was. Unfortunately, I might be able to dig out. I know who dealt with it. So yeah, I think that's it, guys. Yeah. So Will, are you back on Monday night on your channel? I don't know, because you're going away
Yes,
for a bit.
I actually am back on Monday, so I might. I don't know if you guys are around or want to do something better with the bank holiday than
Oh yes, bank
join
holiday,
me,
isn't it?
but I'll
I've not
see
got
if I
anything
can
better to
get.
do.
I beg your pardon.
I've not got anything better to do. So yeah, I mean, yeah, if you want to do something, I'll be around. But yeah, no worries if
Okay,
not.
I'll post if I'm back. I get back on Sunday night, and so I should be okay. So hopefully see you then.
Yeah, cool. And just someone's just said for question 11, which might help out, the poster should ask the local authority if they can bid for a 3-bed parlour house, so they could be turned into a 4-bed. Some councils are recommending this as an option, so that's helpful. Yeah, I think the council's going to have to be very creative about how they deal with that. Yeah, so yeah, cool. All right, guys, we'll be back on this channel a week tomorrow, unless things change weirdly. I can't do tomorrow night, which is why we're doing it tonight. But yeah, again, hopefully this has been at least useful in terms of telling you stuff. I appreciate it's been rather depressing tonight. Not much we can do about that, unfortunately. And I will kind of just this question of, are you still legally homeless if you are owed the Section 193 duty, is something which I'm going to find out a bit more about, because as I say, I'm not really kind of asked that question myself, to be honest. So yeah, that might add to whatever
It has
question it
that
was.
did used to come up in some court cases years and years ago, and I think logically, logically you must be because otherwise they could just say we've accepted as 193 duty, so we're not going to give you any accommodation because you're not homeless. Which,
Yeah,
um, but I
but
think in others, because I think homeless means different things at different times. Like it could mean you're not homeless in the sense that you're not. I appreciate you didn't want to open up the can of worms and discuss the whole thing now, but I think it means different things at different times because you couldn't make a new homeless application if the council's accepted a duty, and presumably unless they've refused to give you temporary accommodation, in which case you would be. But it'd be a bit
Um,
odd.
well, so my thing, I mean, thinking about it a bit more, I guess we've got a couple of minutes. So the fact that you could be found intentionally homeless from Section 193 accommodation says to me that you weren't homeless. That would be my logic there. So if you let's say you were placed in temporary accommodation under Section 193, and then you whatever, punched the landlord in the face or something, and they then evicted you from it, then you could be found intentionally homeless. And that says to me that essentially you weren't homeless. It was essentially settled accommodation whilst you were there, even though it wasn't settled in the ordinary meaning of it. There was a guarantee that you were going to be able to, it was going to be available for some time. That's my thinking. But
Yeah,
I'll have a little dig around that.
and you had a right to settled accommodation, which would have been provided had you not done that. I think there's a
Yeah.
case called AWUA,
How do you spell that?
AWUA. I think it's AWUA, and it goes back. But I dread to think how long ago it is. But it's hang on, AWUA homelessness. No, I'm getting aqua homelessness. It doesn't. Oh, sorry, that's because I'm typing it wrong. AWUA. And it's still not.
I'll
Oh
have a
yeah,
little
there we
look.
go. I'll
Awesome.
put a link in the chat.
Cool.
And the issue in that was whether the duty of a local authority to an unintentionally homeless person in priority need is to provide permanent accommodation or merely suitable accommodation for their occupation. But I think in the course of that, there was discussion of how could they discharge the duty. But anyway, I'll send that in the link.
Yeah, cool. I'll have a little look around and say I'll
Yeah.
report back next week. But yeah, cool. Cheers, guys. See you next Thursday, if not on Monday.